A Guide for Immigrants Accused of Crimes in Florida. Written by Joseph Mitkevichus. Frequently asked questions. Will I be deported just because I was arrested? An arrest alone doesn't deport you. What matters is the outcome of the case and your immigration status. If you're undocumented, being arrested can put you on ICE's radar. And they might detain you, but they still need a legal reason, like unlawful presence or a prior order, to deport you. If you have legal status, they usually wait to see if you're convicted of something that makes you deportable. That said, ICE sometimes takes action on arrests, especially for serious charges. It's crucial to fight the charges and also get legal advice on your immigration situation as soon as possible. What is an ICE hold or detainer exactly? An ICE detainer is a notice from ICE to the jail asking them not to release you because ICE intends to take custody. It typically lasts 48 hours, excluding weekends and holidays, beyond the time you would have been released from jail. For example, if you pay your bond at 5 p.m., the jail might hold you up to 2 more days for ICE to come. Florida requires jails to comply with these holds. If ICE doesn't pick you up in that time, the jail should release you, but usually ICE is prompt if they placed a hold. While the hold is in effect, you won't be released to the street. You'll go from jail to ICE's custody. The police or ICE didn't read me my Miranda rights. Can my case be thrown out? Miranda rights, the warning about the right to remain silent and to an attorney, apply when you're in custody and being interrogated. If they failed to Mirandize you, the consequence is that any statements you made to them might be excluded, not used in court. It doesn't automatically dismiss the charges. If there is other evidence, like physical evidence or witness testimony, the case can continue. Your criminal lawyer can file a motion to suppress any statements you made due to no Miranda warning. This could weaken the prosecution's case if those statements were important. But don't rely on this as a magic bullet. It's a legal tool that helps in some cases, not all. Regardless of Miranda, always remember you have the right to remain silent. Use it. It's the talking that hurts cases, not the lack of a warning. Should I hire both a criminal and an immigration lawyer? If possible, yes, especially if the charges are serious or clearly deportable. A criminal lawyer will handle the criminal court, but an immigration lawyer can guide on what outcomes to strive for and later represent you in any immigration proceedings. Many people hire the criminal attorney first and then consult an immigration lawyer as needed. Some lawyers and firms handle both or will bring in co-counsel. If funds are limited, prioritize the criminal case at the start because a good criminal outcome can prevent immigration problems. But at minimum, get an immigration consultation early on to map out the strategy. And if ICE detains you, an immigration lawyer becomes essential. 14. Can my public defender help with immigration issues? Public defenders are trained for criminal defense. They are required to advise you about immigration consequences to the best of their ability. Many PD offices have resources or a list of consequences for common offenses. Some even have an immigration specialist on staff. However, they are not immigration lawyers, and their knowledge may vary. You should absolutely tell your PD about your status and ask the questions. They should research and inform you. If you sense uncertainty, you or your family might seek an outside immigration attorney's opinion and share it with your PD. Public defenders usually appreciate this information because they want to protect you too. So yes, they can help to an extent, but you may need additional expert advice in complex cases. If the criminal charges are dropped, am I safe from deportation? It's much better for immigration if charges are dropped. No conviction. You won't have a criminal ground of deportation. However, being safe depends on your overall status. If you're undocumented, ICE could still try to deport you for just being here without status, regardless of the criminal case outcome. If you have a visa or DACA, an arrest alone that didn't lead to conviction might still cause issues like visa revocation or DACA termination. DHS has some discretion. But generally, no conviction means you did not hit the crime triggers for deportation. ICE might still look at the arrest, but in immigration court, they need a conviction or certain proof of conduct to deport you for crimes. Bottom line, always aim for charges to be dropped or beaten. It puts you in a far better position. You might still need to deal with ICE if they picked you up, but your lawyer can argue there's no basis to remove you, aside from any status violation, which may be arguable if you have some relief. Also, if you're a green card holder and charges are dropped, you're usually in the clear on that issue, though the arrest could affect things like naturalization until you show it was resolved favorably. I'm a victim of false accusations. Will immigration understand that? If you are truly innocent, and the case gets dropped or you're acquitted, then you won't have a conviction harming you. But if you feel forced to plead to something you didn't do just to avoid risk, it becomes tricky because immigration will take the conviction at face value. If you plead guilty, immigration doesn't really entertain relitigating guilt. One thing to consider: there is something called a U visa for victims of certain crimes who help law enforcement, and a VAWA petition for victims of domestic violence by U.S. citizen or LPR spouses. But those apply when you are the victim, not the accused. In your case, if you're being falsely accused, say someone is trying to get immigration status by accusing you, which unfortunately can happen, like misusing the U visa process, you need to defend yourself in criminal court. Immigration won't label you a perpetrator unless you're convicted. So focus on proving your innocence. If it's a he said, she said, consider a trial rather than pleading. Your attorney might also bring up in negotiations that the accuser has immigration motives, if evidence supports that. Although be cautious, this can be sensitive. There have been instances noted where people made false accusations to get a U visa. It's rare, but it exists. Immigration judges are not part of determining guilt. They only react to the criminal court's findings. So you must win in criminal court first if you're falsely accused. If I get deported, can I ever come back legally? It depends on why you were deported. Some deportation orders come with time bars, e.g. 5, 10, 20 years, after which you could apply for permission to return. However, if you have serious criminal convictions, especially an aggravated felony, you could be permanently inadmissible. Aggravated felons are typically barred for life and can only return if they get a special waiver. Very hard to get. If you're deported for a simple reason, say you overstayed a visa and had one CIMT but qualify for a waiver later, it might be possible down the line to get a family-based visa with a waiver after 10 years abroad or so. Each case is unique. Generally, the more serious the conviction, the harder it is to come back. Some people may be eligible for a waiver if they have a U.S. citizen family who will suffer without them. That ties to hardship waivers and such. But you should assume that a deportation is a long-term or permanent separation. Never plan on just sneaking back. That can lead to federal criminal charges if you re-enter after deportation. It's better to fight to avoid deportation now than to hope to fix it later. I have U.S. citizen kids. Doesn't that protect me from deportation? Unfortunately, having U.S. citizen children or spouse does not automatically protect you. Many people with citizen kids get deported. However, family ties are relevant in some discretionary decisions. A prosecutor might be more lenient in plea bargaining if they know you have family depending on you. An immigration judge can consider family hardship if you seek cancellation of removal. For non-LPRs, you must show extreme hardship to citizen or LPR immediate family. For LPRs, family ties help in balancing factors. ICE sometimes exercises prosecutorial discretion and might not pursue deportation against someone with strong U.S. family ties and no serious crimes, especially under certain administrations. But with a serious criminal conviction, they often won't exercise such discretion. There's also a waiver for some deportation grounds if you have a U.S. citizen or LPR spouse parent who'd suffer extreme hardship, but not for all crimes, not for drug trafficking or ag felonies, for example. In summary, your citizen family is an important part of your story and can help in legal arguments for leniency or relief, but it doesn't guarantee safety from deportation. Never assume they won't deport me because my kids are Americans. They can and do, sadly. What is the Padilla case I keep hearing about? Padilla v. Kentucky is a 2010 U.S. Supreme Court decision that said criminal defense attorneys must advise non-citizen clients about the immigration consequences of a guilty plea. Before Padilla, some lawyers would say plead guilty without mentioning it could get the client deported. Now it's recognized as part of effective assistance of counsel to inform the client if a plea could lead to removal. If a lawyer fails to do that and the client gets deported as a result, the client can sometimes challenge the conviction for having had ineffective counsel. Padilla was a big deal because it acknowledged how crucial these consequences are. In practice, Padilla means you should expect your lawyer to talk about immigration effects, and if they don't, they're not doing their job fully. It doesn't mean every lawyer knows everything offhand. They might research or consult an expert. But it's your right to be informed. If you pled guilty without knowing and got deported or facing deportation, talk to an attorney about possibly vacating the plea due to Padilla. It's complex and often an uphill battle. Courts have various standards on this. It's best used as a safety net. We mention it in this guide so you know your lawyer has that duty. How can I check if a lawyer is legitimate and good? For a lawyer's legitimacy, ensure they are a member of the Florida Bar for criminal lawyers or the relevant state bar. And for immigration lawyers, usually they'll also be an attorney. Immigration is federal, but legit practitioners are attorneys or accredited representatives. You can search the Florida Bar website by name to see if they're licensed and if they have any discipline history. As for quality, look at experience. Do they list criminal defense and immigration experience? Maybe reviews or testimonials? Take with a grain of salt, but they give some insight. A consultation can also tell you a lot. Do they answer your questions, seem knowledgeable about immigration issues, and treat you with respect? Beware of anyone who guarantees a result. Law is uncertain. Also, a good lawyer will listen to your concerns about deportation and not dismiss them. If someone says, "Don't worry about that, just trust me," without explaining, that's a red flag. Trust your gut too. You want someone who makes you feel heard. Organizations like the American Immigration Lawyers Association, AILA, can also be a resource to find immigration attorneys. And as always, referrals from people who had similar cases can help, as long as their case was indeed handled well. What if I just leave the U.S. before my criminal case ends? Fleeing the country to avoid prosecution is generally a bad idea. If you leave while on bail and never return, the court will issue a warrant for your arrest. That warrant will never go away, effectively barring you from coming back to the U.S. because you'd be arrested at the airport for the outstanding warrant. Also, flight can be a separate crime, bond jumping. If you ever get caught in any country that might extradite you, you could face even more trouble. Now, if you are desperate and thinking you'd rather self-deport than risk consequences, note that leaving won't erase the criminal charge. And in immigration law, leaving after certain charges or convictions can trigger bars to re-entry as well. If you're going to leave, it's better to resolve the case first if possible, maybe via a diversion or something that ends it without conviction, and then leave formally. We understand the fear that drives this question, but running away can create more problems than it solves. Always discuss with your lawyer. Occasionally, in minor cases, a lawyer can handle things while you depart, like they can appear for you and maybe get a dismissal eventually, but that's specific. Don't skip out without legal guidance. It closes doors. I'm a DACA recipient. What happens if I'm charged or convicted? DACA, Deferred Action for Childhood Arrivals, has strict rules about criminal history. An arrest itself could get your DACA put on hold, especially for serious charges. Certain convictions, like any felony or significant misdemeanors including DUI, domestic violence, gun offense, drug charge, etc., will likely terminate your DACA. Even multiple minor misdemeanors can. If you're in this situation, aside from normal concerns, you have to protect your DACA status. That might mean fighting to get charges reduced to something non-disqualifying or dismissed. DACA is discretionary, so USCIS could even deny renewal if they feel you're a public safety risk, even without conviction. It's extra reason to avoid conviction. If you do lose DACA because of a conviction, you become just like any other undocumented person and could be placed in removal proceedings. So treat your case very seriously and inform your lawyer that you have DACA. Sometimes they might craft a plea that doesn't trigger DACA revocation if possible, for instance, a non-significant misdemeanor. If you manage to get the case dismissed, or a very low offense, you might keep DACA, but you'll need to consult an immigration lawyer when renewing to fully disclose and show court records. Also, never lie on a DACA application about an arrest. They do background checks, so be upfront with documentation of the outcome. Where can I find trustworthy legal help or additional resources? Here are a few ideas. Legal aid organizations. In Florida, groups like Americans for Immigrant Justice, Catholic Legal Services, Florida Immigrant Coalition, or local immigrant rights groups may offer free or low-cost legal clinics. They might not handle criminal defense but can guide on immigration aspects or refer you to sympathetic attorneys. National resources: the Immigrant Legal Resource Center, ILRC, and Immigrant Defense Project publish guides on crimes and immigration, though these are more technical for lawyers. Community centers. Sometimes community centers that serve immigrant populations have referral lists or partnerships with law schools. If detained by ICE, the detention facility often provides a list of pro bono attorneys or groups for immigration cases. Ask for that list. Online, be careful, but some online forums, like Reddit's Our Immigration, have knowledgeable people, including lawyers, who give general advice. Never depend solely on an online stranger, but you can learn from others' experiences. For instance, reading questions and answers where people describe their cases can highlight what to do or avoid. Just verify any critical info with a real lawyer. Mitigation specialists. If you can afford, there are experts who prepare detailed reports on your life and family to help in court, often used in sentencing or cancellation of removal cases. Your attorney would know about these. When seeking help, avoid anyone who approaches you in jail or at court promising quick fixes, especially if they're not a lawyer. There have been cases of scammers taking money from families with false promises. Always check credentials and get agreements in writing. A real professional will understand your worries and won't pressure you to pay without clarifying what they'll do.